Perez, the Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here for oral argument in case number 1 CACV 16-0734 in the matter of Susan Doty Perez versus Tanya Doty Perez. Counsel, remind you that because we're recording this oral argument, would ask you to please identify yourselves and your clients at the beginning each of your arguments. Each of you will have 20 minutes. Appellant's counsel, if you'll watch the clock and reserve as much time as you desire for rebuttal. And also, please keep in mind we've read the briefs, we've read and received and read the supplemental briefs that were filed, and we've discussed the case this morning in conference. With that, counsel for appellant, you may proceed.
Good morning, Your Honors. May it please the Court, my name is Erica Gadberry, and I am here representing Tanya Doty in this case. The first issue that I want to bring up is what the actual issue is in this case. Now, we have provided the supplemental briefing as this Court requested, but the supplemental briefing deals with parentage. And in this case, the parentage issue has already been decided. That was Doty 1, a case that's not before the Court at this time.
Are we foreclosed? By what legal theory are we foreclosed from revisiting that?
Well, because it's not in front of the Court at this time. It's the same parties, yes, but it's a completely different issue. It's not, we're not revisiting that issue. It's a dead issue. If
there's no motion, in other words, there's been no motion to set aside the mandate that was issued on that case, et cetera.
Exactly. So if they want to file a motion to set aside and relitigate the issue based on McLaughlin, they absolutely can do that. But what's at issue here is the constitutionality of 25-409 and how it applies to visitation with adopted children. I think it's also important to look at the timeline if we still want to talk about whether McLaughlin is appropriate and applicable here. I think it's important to look at the timelines for the petition for reviews, and we've provided that to you in our supplemental brief, and I'm happy to go through it again if you'd like. But needless to say, the petition for review was not accepted, but given to the Supreme Court. They continued the review on that until after the oral argument for McLaughlin had come out. So to say that they didn't know about McLaughlin or they didn't think or analyze it, I think is not really realistic based on the timing of the two. So moving forward on the issue that's specifically before this Court is the issue of 25-409 and its constitutionality.
And more specifically, 25-409C2, correct?
Correct.
That's the only subpart that's at issue here.
Correct. And how it applies to adopted versus unadopted or naturally born children.
And as sort of a foundational question, in the Superior Court finding it unconstitutional, which is the issue that your client has appealed, by definition, it seems that court found that 49C2 precluded Susan's petition here. Is that your understanding as well?
Correct.
Okay.
So the reading of it is that Susan can't bring.
Got
yes.
it.
Yes.
And that's based on, and among others in the supplemental briefing, we requested supplemental briefing on 8117A as well, which is somewhat different than McLaughlin and actually a statute that has existed since territorial days, I think. And is your argument based solely on sheets in that respect?
On whether she can have visitation.
Let me try a better question. Whether these children were born out of wedlock, because it seems to me under 409C2 there are two showings that you have to make to get in the room. How about that? Not factual showings, because none of that has happened in this case. The question is whether the Superior Court properly could consider the petition.
Okay, so, and then you're asking me if our argument is based on Sheets?
Well, let me split.
Okay.
I'm getting there, but
sorry.
bear with me, okay? The statute really has two, and recognizing we're at the pleading stage, two allegations that need to credibly be made, as I see it. The second is that the child, to quote the statute, child's legal parents are not married to each other at the time the petition is filed. I rather gather, given the definition of legal parent, that's not really disputed, that showing absolutely could properly be alleged. Is that fair? Is that, but the rest of that is the child was born out of wedlock. That's sort of the first of those two showings under 409C2. Fair?
Uh-huh.
And that's the provision that the trial court said, based on Sheets, could not be shown or fairly alleged here. Is that right?
Yeah.
And is that, and if I understand it right, that's based solely on Sheets holding, which the Superior Court was obligated to follow, and this court owes respect for, but isn't bound in a way that the Superior Court was. Is that fair?
Yeah, that's fair.
Okay. Now, I've interrupted you enough. Let me be
You're
quiet for a
fine.
little while. Please proceed.
So if I understand what you're asking correctly, you are asking if we're basing our entire argument based on Sheets. And yes and no. I think Sheets does a fantastic job of analyzing the statutes, but what it all comes down to is the language of the statutes. So if you look at the adoption statutes, we have 8117, and in that statute, which again Sheets looks at and analyzes, a parent is not required to adopt a child together, even if they're married. So you have the opportunity to have single parent adoptions. And again, Sheets does a great job of kind of parsing that out in the language. It's very easy to see. You have parent written there in A, and then even in section B, the court or the legislature acknowledges that children, when they're born, have two parents. That's in the second line there. But once you're adopted, you can have one parent. If you look down into ARS 8103, you also have the permissive language that says that parents may jointly adopt. And so in order to read it the way that Susan is asking it to read, you now are giving parental rights to somebody who hasn't adopted.
Which has the whisper, and I'll hear from other counsel later, but has the whisper of reconsidering Doty Perez 1, it seems to me. But let me ask you, on the statutory language of 117A, what I don't know, I know how Sheets reads that an adopted child was born in wedlock as to the world.
As of what?
As to the world.
Yeah.
I wonder, though, if the statute uses slightly different language. It talks about the natural relationship of child and parent thereafter exists between the adopted child and the adoptive parent, as though the child were born to the adoptive parent in lawful wedlock. And what I don't know, if I were a stranger to that statute without the benefit of Sheets, if that would mean out of wedlock as to the world, born in wedlock, pardon me, as to the world, or born in wedlock as to the adoptive parent alone.
I think this court did a great job of explaining that in the Doty 1 case, where it was looking at and analyzing these same exact things. And it specifically says that under the statute, the in lawful wedlock status is only attached to the child through the decree of adoption. The statute thus arranges the adopted child's status relative only to an adoptive parent or parents. So the in lawful wedlock is basically, our reading of it is to give a single parent the highest possible protection that they can have. And it encourages adoptions. It encourages all different things in order to get children out of state care, and it just encourages adoptions. And so if you have a single parent who knows that they don't have to worry about a third party coming in and requesting rights and visitation and such, it gives more incentive to have those adoptions.
And the question I have, though, because it talks about the relationship between the adoptive parent and the the adopted child only. And it doesn't say that the child is therefore born in wedlock. It says as to those two, the child is treated as though the child was born in wedlock. And I wonder if that's a distinction with a difference.
And maybe I'm not understanding your question correctly, and so I apologize if I'm not, so stop me if I'm not answering correctly. But the statute is clear in 25409C that there are limitations to the third-party rights that the legislature will allow. And the protection of not having to deal with a third party coming in and asking for visitation or asking to kind of manipulate your time with your child, it has some blockers. And having it say if your child is born in wedlock, you're not going to have to deal with these third-party rights and these third-party intrusions. Again, that's, we believe, why the statute was written the way that it was written with regard to the adoptive parent and child. Now, if you go in and take out the same-sex issue here and just look at man and woman, and a woman decides that she wants to adopt a child, her husband doesn't want to, she's allowed under the statute to adopt as a single parent. Reading the statute this way now almost forces people into a two-parent adoption when that's not written in the statute, that's not required.
Statute does not require joint parent
Exactly,
adoption. There's no
exactly.
question that's true if it's a same-sex couple or opposite-sex couple. That's true if they're married. That's true if they're not. But under the born in wedlock to the world, you'd have a situation where one person in a couple adopts and then develops a long-term relationship with someone else, say 15 years. And when where that person is sort of the non-adoptive person is sort of psychic parent, for lack of a better term, and there's probably a better term to use than that. If that relationship between the two adults falls apart, the non-adoptive psychic parent has no parental rights. And if they were to go to seek third-party visitation rights under 409C2, if born in wedlock applies to the world, they couldn't seek third-party rights there either. And I wondered, especially given the length of time the statute's been on the books, and it seems to have started with the concept of how you inherit property, and to avoid characterizations of a person's birth that weren't very flattering. Completely apart from third-party visitation, I would be delighted, and I understand if you're not in a position to address that, but if you are, kind of the evolution over time of that provision.
Well, I don't know that I can answer your question as
That's
thoroughly as you'd like
well,
to.
it's a very fair response. And
but I just wanted to point out that the legislature has the opportunity to create these third-party rights, and it has done so, and the statute has been challenged on constitutionality issues 5 to 7 times since its inception. And if we look specifically at the Finnick case, in that case, there was a grandparent, they were step-grandparents, and they stood in loco parentis to the child. I mean, he was living with his grandparents. They were raising him. And when his biological mother wanted him back, she no longer wanted them to have any sort of visitation whatsoever with him. And although the court was sympathetic to the step-grandparents' plights, they were bound by the language of the statute.
And by the statute, though, you mean 409, correct?
Right,
Yeah.
correct.
And was that a C2 case, or was that because they're...
No, so that one, the statute has changed thus far,
Under
so...
415 back in the day.
Right, so I'm only simply bringing that case up to show that you're constrained. So we do have these sympathetic cases where you do, maybe have I don't remember your word,
I use psychic parent, but
Psychic
let's
parent.
not sort of engraft that anywhere, okay?
But, you had a in loco parentis situation, and the child was, the grandparents were unable to get those visitation rights, even though they technically stood in loco parentis to the child. We also have had other constitutionality challenges in the Jackson case, where, and this is kind of circling back, Susan had asked that the statute be viewed under strict scrutiny. And in that case, we have a step-parent and regular, I don't know what word you would use, but not step-parent adoptions. And with the step-parent adoptions, the statute allows for visitation rights of the biological parents, even though they're no longer considered parents anymore. But if you were a regular adoption, all of those rights would be severed. And this court, found that you view this under rational basis. And yes, that's constitutional because adoptive rights are provided by the legislature. And if they want to give credence, or they want to allow, sorry, I just lost my train of thought. If they want to allow these types of visitations, then they're able to do that. And in this case, Sheets came out several years ago, and the legislature did not change the statute in any way. And I think that's telling, because in past cases, especially with the Finnick case and such, the legislature continued to change the statute and to manipulate it in order to address these issues. And since Sheets, silence. We've not done anything.
And that's fair, although silence by the legislature, particularly with a decision by this court as opposed to the Supreme Court, has a somewhat less crisp, connotation to it.
That is true to an extent, but this is a hot issue. Cases have been up. You guys have seen it. The Supreme Court has seen it. And even our United States Supreme Court has been dealing with same-sex issues in parentage and all of that. And again, I don't think this is a same-sex issue. This is a simple visitation issue. Is 25409C unconstitutional as it relates to adopted and unadopted children? And we only need to look at a rational basis, and rational basis are presumed.
And some of the reason, and you've fairly presented that issue in your appeal, but of course we have an obligation when we're presented with a constitutional question like that to see if there's some path through that thicket short of squarely addressing that constitutional issue. And that's what prompted my question on 117. Please continue. Okay. You've been generous and
No, I don't mind. So I just wanted to hit again, and the attempt to classify adopted children as a suspect class, and thereby hiding the review to strict scrutiny as opposed to the rational basis. And again, I just want to point out that the United States Supreme Court has been very specific with the classes, the strict scrutiny classes that are found, and adoption has never been found as a suspect class. And the suspect class is race, national origin, religion, alienage, poverty, or where government impinges upon a fundamental right. I pointed out the Jackson case, and in that case, while it's not adopted children, it's adoptive parents, but this court specifically found that rational basis is the level of review that's done. And we pointed out in our briefs other cases throughout jurisdictions that have specifically found that adopted children are not a suspect class. And so when you're looking at rational basis, you can presume that there is a government purpose behind it, and you don't even have to presume, because as we stated before, promoting adoptions with single parents is an absolute rational basis. And with that, I'd like to reserve the remaining of my time for rebuttal.
Let me counsel before I'll ask our presiding if he will stop the clock, if he'll indulge perhaps a little more time, given that I've sort of monopolized your time.
Yeah, we'll plan on, why don't you add 2 minutes?
Thank you.
Thank you.
Thank you.
Good morning. May it please the court, my name is Marcus Reisinger, and my colleague Leslie Satterley and I represent Susan Perez. Your Honors, I'd like to begin by discussing what I'll call the parentage issue, which the court requested supplemental briefing on, because I think that although these cases, these two appeals represent distinct issues, they're all of these cases are wrestling with the question of how should adopted children be treated. It's clear that the legislature intends, and whether they've accomplished that goal or not is a question to be answered, but it's clear that the legislature intends to treat adopted children on the same footing as naturally born children or children who've not been adopted. And unfortunately, I don't think they've accomplished that. First, I'll point to page 7 of the trial court's minute entry in this matter. In the first full paragraph on that page, the trial court notes, if the facts were such that petitioner and respondent were divorcing and the children were naturally born to respondent, petitioner would have no difficulty petitioning for visitation rights to the children. Now, this minute entry is dated 7/14/2016, which is prior to the McLaughlin decision, prior to the Turner decision of this court, prior to the Arizona Supreme Court's review of the McLaughlin decision and subsequent decision, and prior to Pavon from the United States Supreme Court. I think I would modify that sentence now to say that petitioner would have no difficulty petitioning for parental rights to the children had they been naturally born during the marriage. Instead, as you know, 4 of the 5 children were adopted during the marriage. So because they were not naturally born, we have to look to what the statutes say. We have to look to how the legislature asks the courts to treat these children. Because as we know, adoption is a creature of statute, and the legislature sets forth how those children ought to be treated. And we have case law on point. Sheets versus Meade says that, in paragraph 17, the legislature has made an understandable decision to ensure that adoptive parents enjoy a status equal to that of biological parents. And in Jackson versus Tang Green at paragraph 23, the legislature must act even-handedly when it grants benefits to a group and denies them to another. It's clear that the legislature's intent is that adopted children be treated as though born to the parent. And Judge Thama, I think your point as to whether we're talking about being born in lawful wedlock as to the world or as to the parent is an important distinction to make. But it seems that when I read the statute and when I read the case law that is interpreting the statute, that the legislature doesn't make such a distinction. It says that the child should be treated as though naturally born to that parent with all the rights, privileges, duties, and so on, adhering to that relationship. And it's true that 8117 is an old statute and likely refers to more so property issues than parentage, but I would argue that under McLaughlin and under Obergefell and the other cases, that this is a question that the legislature would prefer the court answer as the children should be treated exactly the same way as children who are biologically born.
Well, let me ask you, with respect to the statutory construction of 117A, for purposes of where we are today, well, let me back up. It seems there were, this case, and Doty Perez 1, in the opinion, represents 2 different paths to secure either visitation or parenting time or its equivalent with these children. The first is as a parent. Doty Perez 1 precluded that, said no, that's not the case. And then the other is as a third party. That's how we're dealing with 409 today. And if the holding of Sheets and its construction 117A remains and governs here, and that's what the Superior Court found, Doty Perez 1 precludes the first option, and 117A, as construed, precludes third-party visitation, which sort of puts us in the jaws of a constitutional question, recognizing adoption is a absolute creature of statute, as you said, and did not exist, as I understand it, at common law. So where does that leave us? Where does your argument sort of present us? Because it strikes me as it seeks to kind of smush together 2 very different paths on seeking visitation, to use a loose term, with these children.
Well, Your Honor, I'll begin by speaking frankly. I think the Doty Perez opinion was incorrect. And I think that in light of McLaughlin, the court must revisit that opinion as to parentage for the 4 children who were adopted during the marriage. Now, the court doesn't have the luxury of resolving the entire case that way because one of the children was adopted prior to the marriage, so the 409C2 issues would remain regardless. But in the Doty Perez 1 opinion, although there is substantial discussion of 25-814, the marital presumption, and the courts at the time understanding that it was a biological paternity statute, which has since been overturned, really what the decision hinged on was this concept of waiver, that Susan failed to petition the court during the marriage to have parental rights with the children. That conclusion fails because if Susan was entitled, as McLaughlin says she is, to assert the presumption of parentage because the children were born during her marriage, then she can't waive that right. A father does not have to, or a parent does not have to assert the marital presumption during the marriage. They do so when the relationship fails, when there's a dissolution action, and that's what she did in this case. So when the Supreme Court reviewed Doty Perez 1, the petition for review, and rejected review, we can only speculate as to why they did so, but it seems as though the decision hinges on this waiver concept, which is no longer legally valid. And if Susan couldn't waive the right, then the court would have to look back at whether she's entitled to assert the presumption, and I think the subsequent case law of McLaughlin would require the court to allow her to do that.
But let me ask you this. It is a dangerous thing for this court, although in our quiet times we may wish to speculate why a Supreme Court denied review.
Correct.
And in fact, I think there's case law saying you really can't attribute precedential fact to that. But what we do know is Doty Perez, for this case in Superior Court, is law of this case. The mandate is issued. That issue is not currently before us. The issue before us is the constitutionality of 25409C2 as applied to this case. So I understand what you're saying, and it is an odd procedural context that is another complicating factor of a complicated case.
It is.
But that's the way the case comes to us.
Well, Your Honor, I cited case law in the supplemental brief, the Dugan case, the Wheats case, the Neal case, that the court can look back on a constitutional issue if subsequent precedent
You bet.
would change the result.
Are any of those cases, though, in the same case where a mandate issued in a prior appeal? The answer is no, and I don't mean that.
I was going to say, no, the answer is no. But I don't think that changes the core issue, Your Honor, that we're talking about a right of parentage. We're talking about a right of equal protection as expressed in Obergefell. So the court should look back. It's true that the adoption statute only allows a married couple to jointly adopt, but as argued in Doty Perez 1, it's a bit of a falsehood because in this case they weren't allowed to jointly adopt and would have done so had they been given the opportunity. The trial court already made that finding. It is an extremely complex procedural posture, but I urge the court to look back at this constitutional issue and revisit it in light of the controlling case law from the Supreme Court on that point. I'll move on to the scrutiny issues because I think that the court, even if it finds that...
Before you do that,
Yes.
let me just ask you, you're inviting the court to look back at the result or the mandate that issued in Doty Perez 1, correct?
Correct.
And is there any reason why you have not moved to vacate?
Well, as the court pointed out in the mid-entry requesting supplemental briefing, the McLaughlin case wasn't decided when this matter was briefed. And it wasn't clear that the court was in a position to reconsider that issue until after the court requested the supplemental briefing. I began looking back, and frankly, it hadn't occurred to me that the court may wish to do that or had the authority to do that, but now we know that it does have that authority and is looking back at those issues.
Counsel, I would encourage you not to extrapolate too far on the supplemental briefing order. McLaughlin was decided, after briefing was done in this case. So the thought that that was an invitation to do anything other than afford the parties an opportunity to brief that case, I think might be a mistake. Let me put it that way.
I understand, Your Honor, but I guess my point is that the issue was not well known, not well researched to the parties at that time. As to the scrutiny issue, I argue that this distinction that's made in 25409C, as described in the Sheets case, would fail under any level of scrutiny. But I'll begin.
Before you get to that, do we have to decide the constitutionality here? I mean, following up on Judge Thelma's questions, I mean, can we interpret this statute in a way that maintains constitutionality and also gives, deference to the legislative intent? Can we interpret it in a way that gives your client the opportunity to seek visitation under C2?
I don't think so. I think the Sheets opinion is clear that there is no jurisdiction for the trial court to consider a visitation request as to an adopted child unless it was a step-parent adoption. And that's why this appeal, or that's why the motion to dismiss was filed at the trial court level, even though these were stipulated orders, because it becomes a subject matter jurisdiction issue that the court can't avoid and the parties can't stipulate around. Under a rational basis test, I think that the Sheets holding fails because, as pointed out in the Jackson versus Tangreen case, paragraph 23, when the legislature elects to give a benefit to a group and creates a distinction, it has to even-handedly grant those benefits. And there must be some relationship to the legislature's goal in the mechanism that they choose to try to accomplish that goal. I don't dispute that the legislature's intent is to give equal footing to adopted children as to children who are biologically born to the parent, but it's failed to do so. In fact, it's counter to the goal, what it's done here, as interpreted in the Sheets opinion, because a child who's born to a person, even during a marriage, would be subject to a visitation petition if the marriage subsequently fails, and there's a party who stands in a position to make that claim. And, of course, the statute empowers the trial court to make best interest findings and to give special weight to the parent's opinions, as described in Goodman. But here, the court isn't even allowed to make those findings. It's a jurisdictional impediment that prevents the parties from getting in the door. The legislature has created a system in which a child who's adopted cannot enjoy the same rights and opportunities that a child who is not adopted can enjoy. If a single parent adopts and chooses to do so without being married, chooses to do so without a joint adoption, they should be in the same position as an individual who bears a child outside of wedlock. But the legislature, in its intent to create equal footing, has accomplished just the opposite, that if that parent adopts, they're given this superior parental status, and the child is given a birth status that doesn't allow a visitation petition to be filed.
Counsel, that would be unless the statute, the adoption statute we've been discussing, is read to mean, as was pointed out earlier, only as to the parent and child, as though the child had been born in wedlock, and not as to others.
Well, I think that's the first sentence of 8117A, and Sheets, if I'm remembering the punctuation correctly, Sheets interpreted the unlawful wedlock language of the second sentence. But regardless, the Sheets opinion, I think, is pretty clear that these children can never be subject to a visitation petition. It's a jurisdictional finding. It's not, there's no distinction made in Sheets between the relationship of parent and child versus the relationship of child to the world, and there's just a complete foreclosure of the ability to file these petitions. I think that's counter to what the legislature's goal was, and that means that the distinction fails under rational basis scrutiny. If the legislature's goal is to put these children on equal footing, but it's accomplished the opposite by treating them differently, then that is not a rational distinction. It's the definition of an irrational distinction. If the court finds that intermediate scrutiny applies, which I think is probably the most logical level of scrutiny given what we're talking about, then certainly adopted children are similar to illegitimate children, which courts have found would be entitled to intermediate scrutiny. There are statutes where the legislature has expressly attempted to give adopted children rights on equal footing with naturally born children. 8117 is one of those. ARS 38762 is another, which grants survivor benefits to adopted children for Arizona State retirement on the same terms as a naturally born child would receive. The fact that the legislature has enacted these statutes to try to give those children equal footing tells me that there has been some historical discrimination, as there was with illegitimate children, and that's the purpose of these statutes. So I would urge the court to apply at least intermediate scrutiny.
Though, counsel, let me ask you, if in fact this language or language akin to it has been around for decades, What you're arguing is that that distinction between adoptive children and natural-born children reflected in this case 409C2, but also in 117, because that kind of drives it, has impermissibly and unconstitutionally made a distinction between natural and adoptive children since adoptions became legal in the state.
I think that from an academic standpoint, that's correct. But practically speaking, we've only had this issue in front of us since the Sheets opinion was decided. My understanding is that before that case, adoption or children who were adopted were being subjected to visitation petitions, and the courts didn't see the distinction here that Judge Swan found in the Sheets opinion. So, although correct that this was incorrect from the beginning, it's not an issue that we've had to deal with, and it's now before the court because the Sheets case prohibits these petitions. And from what I gather, the family law community understands this as a complete bar.
Sheets, though, in doing that, applied a Division II case with a series of numbers in it, a grandparent visitation,
something,
right, case that had two adoptive parents, didn't it?
I believe so.
Right. Okay. Let me, and again, you've been generous with your time as well. What remedy, if your position would carry the day, would that involve?
My request to the court is the same request that was made to the Supreme Court in McLaughlin, which is to treat these children the same way that they would be treated if they were not adopted, as if they were naturally born during this marriage.
Aren't the factors quite different here, though, given the statutory, given that adoption is a creature of statute?
Well, they are different, but the statutes tell us that we should treat the children the same. The statutes tell us that we should treat the children as though born to the person.
But in terms of the remedy, because McLaughlin, where the court took differing views, was on the remedy.
Correct, on the estoppel issue.
Be it judicially driven or legislatively driven. And that was in a context sort of that was in natural birth as opposed to adoption. And I think we're on the same page, that adoption is a creature of statute, wouldn't that drive perhaps a different route if your position carried the day?
Well, I think if the legislature intended a different remedy to apply, it could have enacted a statute to that effect. But what it's told us is that these children should be treated the same way. And I don't think it's disputed that if the children were naturally born during this marriage, then Susan would be a parent, or she would at least have the opportunity to assert the marital presumption. And as to the child who was adopted prior to the marriage, because the child was not born into lawful wedlock, she could assert in loco parentis visitation rights as to that child. But according to Sheets and according to Doty 1, she's not allowed to do either of those things.
Well, although, and I know the fifth child isn't before us, but under the current law after Sheets, she would not be able to seek in loco parentis rights, correct?
Correct. And that's why we're here, Your Honor.
Well, you're not here for that. We're here for
What I'm trying to say is that we're here on the visitation petition, which applies to all 5 children, the 4 who were adopted during the marriage and the one who was adopted prior to but during the relationship. Because Susan asserted her in loco parentis rights to those children, to all 5 children. So we are here to consider the prohibition against the visitation with that child, as well as wrestling with the concept of whether Sheets in 8117A and McLaughlin dictate a different result as to the 4 children who were adopted during the marriage. So again, I'm asking the court to treat the children the same way as it would treat children who were born during the marriage, which is what the legislature asked the court to do in 8117A.
Counsel, in fairness, can you stop the clock for a second? I'd like to give you 2 more minutes if you like the time. You don't need to take it, but would you like?
I would like about a minute, Your Honor.
Why don't you go ahead and add 2 minutes, please, Danny? Thank you.
Thank you. There was a standing issue raised in the pleadings, which I'll touch on briefly. I think Kerr versus Killian controls that Susan has a substantial enough relationship to assert the children's constitutional rights. The children's rights would be diluted if they were not, if Susan were not allowed to bring those claims on their behalf. Forgive me, Your Honor, I lost my train of thought. So ultimately, what we're asking, again, is it's not disputed that if the children were naturally born during this marriage, Susan would have the opportunity to assert the marital presumption. Now, whether Tanya would be stopped from rebutting that presumption is a question that hasn't been raised. We saw in McLaughlin that in some cases there is estoppel, and we can imagine cases where there's not. But she's not been given that opportunity, and I think the court in Doty Perez 1 erred in that regard. And as to the visitation issues, we're asking the court to look at this from the perspective of the children whose rights are being violated. The children do have a right to be free from arbitrary discrimination by the legislature. And again, I don't dispute that the legislature's intent is a good one, but they've accomplished it in a way that results in the exact opposite of what they're trying to accomplish. The legislature wants these children to be treated the same as naturally born children, and I understand why they want that, but they've accomplished something different and prohibited them from having the opportunity to form these in loco parentis relationships. There was one point raised in counsel's argument that suggests sort of a slippery slope, that any person who adopts could be subjected to these petitions. And again, that would put those parents in exactly the same position as they would be if they bore a child. If they're married, then their position can't be assailed. If they're single, then the child is out of wedlock. And I don't think that's a result inconsistent with what the legislature asked of us. I urge the court to treat these children the same way as it would treat children who were naturally born at the times they were naturally born, given the statuses of the parties, and apply the case law as we now know it to be. Thank you.
Thank you.
So I want to address first, and Judge Thumma, you had brought it up, the Sheets case is based on that Maricopa County case, and that was 20 years ago. So we have had this precedent for, 20 plus years. In addition...
We had, but because it was a two-party adoption, there was no other potential parent sort of out there.
But again, if we're now saying there's a potential parent...
Well, I mean, the point being, if a couple jointly adopts, there's no third person that's going to come in and claim any sort of parental rights in that respect.
So we have that, but then the Sheets case goes on to clarify it, and if you are a single parent, you now have the protections that a two-parent adoption or a parent in lawful wedlock, it just provides a level of protection to the parent. It gives them the opportunity to exclude people that they feel are a bad influence on their child. It makes it so that they're not forced to share parenting time. It just gives them a level of control of their child that they...
Doesn't it then also give them more protections than a child who was born outside of wedlock, naturally born to their parent?
It does, and I think that was the legislature's aim. Encourage...
Adopted children differently or with some advantages?
Not treat adopted children. We need to look at the parents in this case. Parents have a fundamental right to the care and custody of their children. Single parents, if the statute for a single parent who has a child out of wedlock has a third-party risk, I guess, so to say, but to encourage single-parent adoptions, that risk is gone now because the child is born as if in wedlock. So they no longer have these third-party risks, I should say.
So then the single parent is in a less protected position than the adopting parent?
Per the statute, yeah.
So the single parent could presumably say, I'm going to have someone else adopt this child so that, let's say, a grandparent won't intervene. Is that what the statute would?
So you're asking me if a single person can have another person adopt, so now they have a two-party adoption?
The single person does not have the protection of having their child treated as though that child was born in lawful wedlock.
The single biological parent.
The natural parent.
Uh-huh.
The natural parent. So we have a single parent. Let's say we have a single mom over here who has grandparents wanting to intervene and obtain visitation with the child. And the statute allows that.
Correct.
That's what it contemplates. Now, your position is that what the legislature did was to allow another single mother, let's say over here, who adopted a child, is protected.
Exactly.
Grandparents, no one else can step in because this child adopted is born in wedlock, and the first child is not born in wedlock.
Yes, that's exactly what, and Sheets says that, I don't want to bore you with the exact language of it, but.
No, please do.
Okay.
Please.
He says, we recognize that 25409C2 requirements may lead to some counterintuitive results. By requiring that the child be born in wedlock, the statute may treat similarly situated families differently. For example, divorced parents of a biological child have superior rights if they marry their child before if they marry before their child was born rather than after birth, even though in both circumstances the child experienced the failure of the parents' marriages, and rights of divorced biological parents who sought dissolution around the time of their child's birth will depend on whether the dissolution was pending or concluded at the time of the birth, though in both circumstances the child was born into a failed marriage. Nevertheless, the legislature has decided to ascribe the importance in the marital status of a child's biological parents at the time of birth.
Counsel,
Yes.
can I ask, and I know that paragraph well, and I know I've promised mentally not to interrupt you, but I've
You're
now
fine.
violated that again.
You're fine.
Would those two hypotheticals in Sheets, would those parents would have parental rights? You'd never get to 409C2 for those individuals. They'd seek rights as parents.
I think the main thing that we need to look at here is the legislature's intent to provide single parents with the highest possible protection that they can have. And it encourages adoptions. If you have a parent who knows, if I have a boyfriend or if I have, somebody that comes in, they can't get parental rights. Whereas without having that, it could create a bar to adoption, because now, all right, I want to adopt this child, but now I have to worry about someone else coming in. Unless you have any other questions, my time is expired.
To go back to my earlier hypothetical, then the first single mother, natural born child, could then relinquish her rights, have someone else adopt the child, and block somebody else that way from obtaining visitation. And to the question Judge Thama asked earlier, isn't that sort of an infirmity with the logic in the Sheets case, the fact that we wouldn't be talking about 25409C2 at all with biological parents?
Again, the visitation rights are provided by the statute, and so of course there's going to be some distinctions and some different things. Bringing up the Finnick case again with the biological parents or biological grandparents versus step grandparents, and whether visitation is appropriate there. In addition, the Jackson case, where if you are a outsider coming in to adopt the child, then you cut off all visitation with any family, but if you're step parent, then those visitations are not cut off. And so it's really up to the legislature on how they're going to allow third parties to come in. And in this case, for single parent adoptions, the legislature has said, you get all the protections. You don't have to worry about third parties coming in and trying to intrude on your fundamental right to parent. Thank you.
Thank you, counsel. Thank you both for your helpful arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court is now adjourned.